Ms. Anand, I think I would really like to hear you address the presumption of consistent usage point in the waiver and the exception, because I think that's a harder argument for you. Because when you describe loss of property, loss of mail, whatever, as the kind of damage, then it can cover intentional and negligent torts. Now, you handle that in your brief, but I would just like to hear you talk about it a little bit more, because I think that is one of the hard parts of your argument.
Sure. So we don't think the presumption applies, and if it applies, it's overcome. So we don't think it applies because that presumption is where two words are being used in the same sense about the scope, right? So interest in the Internal Revenue Code. If it's talking about the stuff you get when you leave your money in the bank, in both places it must cover compound interest, or in neither place. But that doesn't mean that in the Internal Revenue Code, someone can't use interest to mean, present interest in an estate, right? A claim or entitlement. The presumption of consistent usage says, if both terms are being used in the same sense, then they cover the same terrain. Here we submit that it's clear that loss in 1346B is being used in a different sense, the deprivation sense, than in 2680B. And our kind of three textual clues for that. The first is that in 1346B, there's a specific reference to wrongful conduct on the part of the government employee. Second, the sentence is structured differently, right? It's asking, did the government employee cause the plaintiff to lose property, not just if the government employee lost property. And third, as the government itself acknowledges on page 11 of its reply, loss of property is something of a term of art, and when used that way, loss of property, loss invariably means deprivation.